All set whenever you guys are ready.
All right, just we'll be bringing up that female first.
Okay.
Go ahead and step up here and state your full name to the judge.
Hi there. Your name, please?
Do I have the right to remain silent?
You do when we come to information, but this is booking information and verification of information of who you are and to make you aware of your charges.
Okay.
Okay?
Sarah Ann Holke, Your Honor.
Thank you.
Thank you, Your Honor.
All right, Miss Holke, give me a moment here. The state is alleging a total of 7 charges against you. There are 4 felony charges and there are 3 misdemeanor charges. I'm first going to discuss with you the felony charges. The allegations that are made against you are 2 counts of resisting arrest, 1 count of dangerous drug possession or use, 1 count of drug paraphernalia possession or use. The misdemeanor violations is a DUI violation, a failure to comply with a court order violation, and then the obstruction of governmental operations violation. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for 2 different hearings. One of them deals with the felonies and one of them deals with the misdemeanors, okay? First off, the felonies. I've scheduled you for a preliminary hearing on February 2nd of 2026 at 4 o'clock p.m. The preliminary hearing is to determine if there's probable cause to charge you with those felony allegations. If during that hearing there is probable cause found, then your case will bind over to the Gila County Superior Court. If probable cause is not found, then those felony allegations will dismiss. There's a possibility that the case will go in front of a grand jury. If that is the case, you'll be notified by mail to that address that you do not need to appear on the 2nd of February. Best thing to do for you is to call the business day before that date to see if the case is still proceeding. Your release conditions are the following: obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court, do not possess or consume any alcohol or drugs without a valid prescription, and do not possess any firearms. Regarding the misdemeanor violations, I've scheduled you for a court date on, it's actually the same date, February 2nd at 1:15 p.m. So at the hearing for the misdemeanors, we'll try to inform you if the 4 o'clock hearing is going or not, so you'll be made aware of that.
Excuse me, Your Honor.
Yes.
Repeat that, please.
Okay, so that you have 2 court dates. You have 1 court date for the felonies. That's the one I just talked to you about on February 2nd at 4 o'clock p.m. On the misdemeanors, it's the same court date but a different time. So that time is at 1:15 p.m. So at 1:15 p.m., we should be able to inform you if the 4 o'clock p.m. one is or is not still proceeding. So that should be able to happen. Okay?
Thank you, Your Honor.
You bet. The The hearing at 1:15 p.m. is dealing with the misdemeanors, and that's called an arraignment. That's where you'll need to be prepared to plead either guilty, not guilty, or no contest at that hearing. Depending on how you plead will be what happens next with the court proceedings, and all of those options, as well as the penalty ranges of the misdemeanors, will be explained to you prior to you giving your plea, so you'll be well informed. The release conditions are the same for the misdemeanor violations as I've discussed with you on the felony allegation. Do you have any questions about any of that information?
Yes, Your Honor.
Okay.
Um, So, Your Honor, I had a question. Do I have an attorney to talk to now about this?
Yes, I was just going to get to that. So let me give you the next chapter, and it might explain all those things. So regarding your release on the felony allegations, I'm placing a $15,000 bond hold on you, so you remain in custody on a bond on the felonies. There's an additional $1,000 on the misdemeanor violation, so a total of $16,000. Being that you're held in custody on the felony allegations, you have the right to a court-appointed attorney if you cannot afford to hire one. So with your paperwork, I'll be sending you a financial statement for you to complete. And if you qualify for a court-appointed attorney, one will be assigned to your case. That won't happen until a complaint files. So let me explain that process. Since you're held in custody on a felony allegation, the prosecutor has 48 hours from the date and time of this hearing, not counting weekends and holidays, to file a formal complaint against you. If they fail to file that formal complaint against you, you will be released on your own recognizance without having to post the bail of $15,000. And the state then has the ability to file the charges up to 7 years from the date of your arrest. If they do file the complaint within the 48 hours, then your attorney will be assigned if you qualify financially. They'll be made aware of your in-custody status, of your charges, and be in touch with you shortly thereafter. You understand that?
Yes, Your Honor.
And then being that you're held in custody on the misdemeanor allegation as well, one will be assigned to that case as well.
Okay.
Do you have any other questions? Does that answer your questions?
Well, Your Honor, I have a lot of questions, and
So this isn't really the time for the details of the case, and I want to make sure make sure you don't say anything incriminating, and I assist you to
Okay.
protect your rights. Again, this is the formal process to find out, confirm who you are, your address and information, make you aware of the formal charges against you and any release conditions.
okay.
Okay, so we've accomplished those things. Do you have any questions about inside of what we just talked about?
I don't see well, and I need to have some glasses, and I also don't have any denture glue, and it's hard for my dentures to stay in.
Okay.
Is that something that could be provided for me here?
Yes, so when we're done here, just talk to the detention staff about that. See if they can allow you a phone call to get some of the things that you need wherever they're at, the glasses and to a trusted person that you would want to call to go to your house or wherever those items are to get those and bring them to the jail cell. The staff can assist you with how to go about doing that.
Okay.
Any other questions on that?
I'm mental health. I'm SMI.
Okay.
So, Your Honor, can I be provided services from SMI?
Yeah, if you need to talk to a counselor, they can arrange that and summons a counselor for you. I know that you already spoke to somebody already, right, upon the arrest?
Yeah, but I'm suffering terribly right now, and I might need more services in this time.
Okay, so yeah, just let the detention staff know, and they'll summons the same folks back. I don't know if it'll be the same person,
Right.
but they'll be the same company to come back.
Okay.
Okay.
And okay.
Okay, is that all?
Um, um, uh, how can I request the body cam footage from that time?
You
for this?
can, but it's very premature right now. Again, that's kind of details of the case. That's not what this hearing is about, but we'll see how the case proceeds, whether you hire an attorney, whether one appoints to you, then you just let your attorney know what you'd like.
Okay, so I wait till that time happens in 48 hours from now?
Yeah, so, well, yes and no. So you're in custody until the court date that I told you,
Oh, right.
unless a complaint does not file. If a complaint does not file, then you'll be released on the felony side of that. Then you'll have to decide whether you want to hire an attorney at your own expense or proceed without one to help get some of those requests that you were asking. The misdemeanor will still have $1,000 that will be in place until that court date, regardless of anything else.
The misdemeanor will have $1,000 bond in place?
Correct. There's $1,000 on all of those misdemeanors, and
Okay.
the 15,000 on the felonies.
So even on the felony charges, if they are not going to formally
Right. File the complaint.
file a complaint, then
The
I'm still going to
misdemeanor.
be held on the misdemeanor
You're right. Under the
bond for
$1,000.
$1,000
Correct.
until the date of my court on the 2nd of February.
Correct. Yes.
Okay. All right.
And you can bond out on that 1,000, so it's bail bonds eligible. You're allowed to go through bail bonds or post the bond yourself, so you can bond out.
Okay. Right. And so, so if they don't take the formal complaint, then I would have to hire my own attorney. You would not be able to appoint a court-appointed attorney.
Not at this time, but if a complaint files later, like I said, they have up to 7 years, then you might be able to have a representation by the court, but that would be a different court. That'll be the Superior Court, and then they'll give you instructions on that. Or you
Okay.
can hire one right away whenever you would like to at your own expense if you needed to. Okay?
Okay. And is the money that I came in with I was able to get transferred to my books, or where I can receive commissary?
Yeah, talk to the detention staff about that. I have no idea.
Okay.
Okay?
Okay, Your Honor.
All right. Have a good day.
Put that back on?
Right.
Hold up here. Come on, please. You'll step over the end of the table there and state your full name to the judge.
Hey, how you doing? My name is Raymond Moody.
All right, Mr. Moody, do you have a middle name also?
Theodore.
Thank you. The state has alleged one violation against you, misdemeanor violation of failure to comply with a court order. On that charge, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for an arraignment on February 18th at 9 o'clock a.m. The arraignment is where you'll need to be prepared to plead either guilty, not guilty, or no contest to that charge. Depending on how you plead will be what happens next with the court proceeding. All of those options, as well as the penalty range for that charge, will be explained to you prior to you giving your plea. Your release conditions are as follows. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if your address changes. Do not leave the state of Arizona without permission of the court. And as we've discussed, provide the your address before being released. Can you comply with those release conditions?
Yes, sir.
All right, sir, I'll release you on your own recognizance. Do you have any questions?
No, sir.
Okay, all right, have a good day.
Thank you.
Well, step to the counter, state your full name for the judge.
Jason Andrew Bernard.
All right, Mr. Bernard, we've got a few matters to take care of. First, we'll go with the current allegation that is made against you. Let me confirm that you're... All right, so the state is alleging one charge of driving on a suspended, revoked, or canceled driver's license against you. What I'd like to do with your permission is, instead of scheduling you back for another court date that presumably you wouldn't attend,
Well, that's presumably. Sometimes you don't have a license, you can't make it. And plus, you guys gave me discovery like 3 days before the court date.
Okay.
So, I mean, it was almost like you guys set me up to fail. But that's here nor there.
Are you done?
Yeah, I'm done.
Okay. That's the other matter that we'll talk about. So I'm going to save all of what you just said for the next portion of this. I don't want to get crossed up on it. So with your permission and consent, instead of scheduling another court date where you're ordered to come to court, with your permission, we can waive that physical presence and do it right now to save you one step of this new charge. What you would be doing is waiving your personal presence and allowing this to occur by video right now, and we can move to the next proceeding and arraignment, I can take a plea on this charge. But you would have to waive your personal appearance to that. You don't have to waive your personal appearance. If you don't, I'll schedule your next court date.
Okay, well, what if I can't make my next court date due to the mitigating factor of another court date? I must.
Well, if there's a court date that conflicts, you have another appointment or some reason that you can't come to court, you can certainly motion the court, put a motion in. That's called a motion, where you're requesting to have a change of court date.
Right, but you already put in a plea for the first. So we're just dealing right now with the matter at hand, correct?
We're dealing with the current charge of driving suspended.
Right.
That's
Well,
why
I'm not guilty of that because once again he pulled me over for no valid reason.
Okay, so, all right. Then that answers a lot. If you're wishing to plead not guilty, first off, before I can accept your not guilty plea, I have to back up one step and ask if we're waiving your personal appearance, so I don't have to order you to come back to court, and then to do this by video. Do I have your consent?
Yes, you have that right.
Okay.
Yes,
Okay. So then, understanding that you've pled guilty, now the only thing I need to do is
I pled not guilty.
not guilty. Correct.
Right.
Yeah. So the only thing we have left to do, I need to explain to you a portion that you have your attorney rights. Okay.
Right.
So there's no jail time asked of this case. So that removes the ability to have a court-appointed attorney because I'm not going to order you for jail on this case.
Okay.
So if you wanted an attorney, you'd have to hire one at your own expense or waive the presence of an attorney, at least for now. You understand that?
Yeah, so I'll go pro per. That's fine, pro se.
Okay, so I'll be sending you a form that does two things: waives your personal appearance that we talked about, and does number two, waives the presence of an attorney, at least for now. You can change your mind later if you wish, but as for now, you can waive in that. So you'll receive that waiver that does both things. Okay.
Okay.
All right. Let me get that out of the way. Enter your not guilty plea. All right. Okay, what I'd like to do is discuss with you your release conditions. Those are the following: obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court. The other one is not to drive a vehicle on a public roadway unless you're licensed to do so. Do you understand those release conditions?
Yes, I do.
All right. So I will be sending you your court date for a pretrial conference. What that pretrial conference is with your not guilty plea. You'll meet with the prosecutor, have a discussion with the prosecutor. They may present the police report and any other evidence that they may have that they're going to present at a trial at a later time. Be careful what you say in that pretrial conference. You can self-incriminate. You're allowed to speak if you want, but just be aware of that. And at the conclusion of that pretrial conference, one of three things will occur. One, the case will in fact go to trial, or two, the case will enter a plea agreement that all parties agree on, including yourself, or three, the case is dismissed. You understand that?
Yes.
Okay, so that court date will be coming. So let's go on to the other matters that we were discussing. We had a trial that you failed to appear for. We didn't, and I understand that you said, well, I didn't get the discovery in time and I couldn't prepare and do all that. Well, there was no motion for a continued court date or any other literature on that case at all. So we proceeded. Right. So you certainly had the right to do all those things, but you didn't. So we tried that case in abstention. You were found guilty for the criminal violation and then found responsible for the traffic violations. Do you wish to say anything before we move forward to sentencing on that? And that's going to close this case.
No, Your Honor. Just, I mean, you understand I went pro se on that, and yes, it was my fault, so there's nothing really I could say.
Okay.
I was not able to make it to court, and I should have let you guys know that, but.
Okay. Well, and then if you can't, then what you can do is motion the court, get us a motion, and the judge, me or another judge, will look at it and see if the reasons why you're asking for a continuance or any of that qualifies. So there's a decision still to be made. And if it does qualify, then they can absolutely grant that motion to get and reschedule the court date. So know that that's available to you if and when this other case proceeds on. Okay?
Okay.
Anything else you want to say before we do the sentencing on that? I'll make you aware of it.
No, Your Honor.
All right. So I want to refresh your Just so you know the violations that were, so the count A violation was the driving suspended, and this occurred on August 3rd of 2024. The
Right.
count B violation was displaying suspended license plates because of financial responsibility, meaning insurance. The count C violation was no mandatory insurance. It wasn't insured at the time of the stop, and then the no registration at the time of the stop as well. Then the final violation was no valid driver's license. What I did on that charge, I'm going to start from backwards to forwards. I dismissed that case because you can't have a driver's license if your license is suspended. So I dismissed that charge, even though you weren't here and all that. I just dismissed it. Actually, the prosecutor requested it to be dismissed as well. So that request was granted. The other you were found responsible for on the other violation. So the driving suspended violation is an imposed fine of $570. Now, I want to give you the ability to correct that if you can. If you're able to get a driver's license within 30 days of the sentencing, which is today's date, I'll reduce that fine to $202 to give you a savings on that day. It encourages you to get compliance with the law. If not, the $570 stays imposed. The rest of the charges, the count B violation, which is the suspended registration, that's an imposed $495. That's governed by the violation. The no insurance violation is $943. Now that's by statute, but there is a way that you can reduce that. If you're able to provide a 6-month policy of insurance on that vehicle, plus a 39-month driving record that shows no prior insurance violations, that will reduce to $184. So that's a significant savings on that, from almost $1,000 to $184. So if you're able to do that, that'll reduce that amount. The registration violation is $585. So we have a total balance due to the court without any of the deductions we talked about of $2,593.50. Regarding payment on that, are you able to pay that?
No, there's no way of that.
Okay, I can put you on a payment plan, so that I have to, by statute, add a $20 payment plan fee. So the balance is $2,016.13.50. How much can you afford per month on that?
Well, I don't know if I'm going to be how long I'm going to be incarcerated, so I can't answer that.
Okay, well, I'll make the payments due every 30 days, and if you can't because you're incarcerated, then you can send a motion regarding the payment that's due for the month that you have the conflict for. And I'll give you an opportunity. I'll extend the first one out a while too, so you know how the things will land.
Okay.
But what about your monthly allowance? How much can you afford on that?
Oh, yeah, I mean, for $50. Let's start out small. And
Okay. We'll start it at $50. You can always go up if you want to clear the debt, and then I'm going to schedule you out 45 days. It's normally due in 30, but I'll schedule it 45.
Okay.
If that date is a conflict, you can motion the court. Make sure
Okay.
you make your payments timely, otherwise they'll warrant your arrest for the failure to make the payment. So let me count that day out. Give me a moment here. 1.
Okay, so I have 45 days. Then then if I'm incarcerated up in a different county, then can I file a motion through a different county?
Yeah, so you could send us an email.
Okay.
Hopefully the staff there, or a fax. They might even be able to allow you to do a fax if you're incarcerated.
Okay.
Let them know that you have a payment due, but you've been incarcerated the whole time. You need to notify our court
Okay.
regarding the payment to see if you can have that payment suspended and pushed up another 30 days or whatever. You'll know more dates by that.
Right.
Okay. 1, 2, 3, 4, 1. I'm going to go to March 6th, so 3/6 of 2026.
Okay. And that's first payment. Okay.
That's when the first payment is due. On the bottom of the judgment form, you're going to see ways that you can make the payment remotely. You don't have to come into the court. Our address will be on the form. You can send us a check or money order, or if you want to use the remote methods, there's a 1-800, and then there's a website that you can pay that. You'll have all the information on the form that you need to be able to do that. Do you have any questions on that?
None.
All right, sir. I also am going to be sending you what's called a notice of warnings and rights. So what that is there are possible collateral consequences upon this conviction. The key word there is possible. I'm going to read those to you now. That's the possible suspension of your driver's license, an impact on a commercial driver's license or other professional license, an impact on insurance rates, the revocation of probation or parole, an increased penalty for further criminal charges, becoming a prohibited possessor if convicted of domestic violence charges, and if you're not a citizen of the United States, a plea or finding of guilt may result in your deportation or being denied citizenship or reentry. So that letter is going to be sent to you. It's also going to explain to you how to set aside the judgment of conviction and how to seal the records, and that's according to statute 13905 and 13911. So it'll give you instructions on how to go about doing each of those once some timelines pass after the conviction is entered. Do you understand what I'm telling you? That
Yes,
letter,
yes, well, this isn't a felony conviction, it's
No.
still a misdemeanor, right?
correct, yeah, but you
Yeah,
still can
okay.
seal those and set them aside if you wish, and it'll give those instructions on how to do that.
Okay, now, okay, so, but now it is, since I'm already in violation of probation, is this a violation of probation in itself? Can they use that retroactively?
Well, we're getting to that. So Navajo County has a probation warrant for you.
Right,
Okay, so there's no bond on that. So you'll be held for Navajo County regardless. They're going to be notified to pick you up that I've released you on all of our stuff. So I'm releasing you, giving you the court date for that pretrial we talked about earlier. We just
Okay.
finished the case that you didn't appear on the trial and finished the sentencing. So that one will conclude besides the payment portion. So
Okay.
then all you have is that other pending one. I'm going to give you a court date. You'll be signing for that court date to appear for that. And I'm going to push it out a little bit because I know you have other things operating as well. So
okay.
does that answer your question?
Yes, yes, Your Honor.
All right. Do you have any other questions for me then?
No, what's the Navajo one for? Do you have that information or?
Yeah, it's very vague in general, but it's a probation violation warrant. They don't say why you're on probation or any of the details of it. They want to discuss it with you because they put a no bond on it. So it's not
Okay,
built.
well, isn't all probation violations no bond?
No,
Oh, they're not.
no.
Oh,
Yeah,
okay.
they can put a bond on a probation violation. Oftentimes you see them, but it's not unusual to see a no bond probation violation either. So it's
Okay,
just
so
a
what time frame do they have to come pick me up?
good question. It's what they call a reasonable time frame. So if they're not there within 10 days, then we request a hearing for it. So
So am I going to Globe or am I staying here?
good question for the detention staff. I'm unsure about that. What they'll probably do is call Navajo County and say, hey, when are you going to be here? And that might have relevance of where you are or where you go.
Okay,
But
yeah, okay. All right, Your Honor. Yeah, because I have people I need to call and things to adjust.
Let the detention staff know that you need to make a phone call so they can get that to you when they get some convenience.
Okay.
Any other questions?
No, when do I receive all this paperwork this time?
As soon as we get done talking and I enter a couple of court dates and get it sent over to you.
Okay, all right. Thanks, Your Honor.
You're welcome.
Okay.
Go ahead and file.
Send it to you, Mr. French?
Yes, sir.
Okay.
And I'll try to work on my handwriting as well.
Oh, that's okay.